Let's start in Colorado. Former President Trump's legal team officially has petitioned the Supreme Court to overturn last month's Colorado Supreme Court ruling that Trump engaged in an insurrection on January 6 and therefore is barred from the state primary ballot by the 14th Amendment. The Colorado Republican Party already had appealed the decision, and because of a stay on the ruling, Trump's name will appear on the ballot until the U.S. Supreme Court takes action. Trump's lawyers argue the 14th Amendment statute does not apply to the presidency. He slammed the ruling that, quote, if allowed to stand, he said, will mark the first time in the history of the United States the judiciary has prevented voters from casting ballots for the leading major party presidential candidate, end quote. In a separate statement, the Trump campaign wrote, Democrats are obsessively violating the American voters' constitutional right to vote for the candidate of their choice. This is un-American, unconstitutional act of election interference, which cannot stand, end quote. That's from the Trump campaign. The Supreme Court still has not announced whether it will accept the case. Joining us now, conservative attorney George Conway and NBC News legal analyst Andrew Weissmann. He's co-host of the MSNBC podcast, Prosecuting Donald Trump. Guys, good morning to you both. Andrew, let me start with you on this appeal up to the Supreme Court. Where does this go from here? Do you suspect the Supreme Court will hear any of this?
I do think that they will take this. I think it's one where the government is not going to oppose and is going to think that it's appropriate. As we know, there's another case in Maine that will bubble up as well. So this is one where if you're not going to have a patchwork of decisions within the states with no Supreme Court guidance, I see the Supreme Court taking it. This is one where Donald Trump actually has a fairly good chance, I think, of prevailing, but you wouldn't know it from the brief that he filed, which is much more of a political statement. I mean, you would think that a brief like this filed by the former president would start with the point that he did not engage in insurrection. That is not his lead argument. I mean, you'd think that should be something that you would want to declare loud and clear, but that's not where we are as a country. That's sort of buried in his papers as almost a throwaway argument because, in fact, there's so much evidence that he did. Instead, he leads with the argument that you quoted, which is that you would disenfranchise so many voters in the Colorado case, over 1 million voters in the Republican primary, which is, of course, a very ironic argument for him to be making, given that he is currently criminally charged with attempting to disenfranchise 80 million people who voted for Joe Biden. So that's the irony is, I think, not going to be lost on a lot of people in the Supreme Court.
So while former President Trump presents confidence in public that he will prevail against the cases challenging his eligibility to be on the ballot in those two states, privately, new reporting says he's worried that the Supreme Court, he stacked with conservatives, will not rule in his favor. The High Court has ruled against him several times in high-profile cases, including when Trump tried to stop Congress from obtaining his tax returns and when Trump wanted a special master to review the classified documents seized from Mar-a-Lago. Trump lawyer Alina Habba acknowledged the former president's concerns in an interview yesterday.
Yeah, that's a concern that he's voiced to me. He's voiced to everybody publicly, not privately. And I can tell you that his concern is a valid one. You know, Republicans are conservative. They get nervous. They, unfortunately, are sometimes shy away from being pro-Trump because they feel that even if the law's on our side, they may appear to be swayed much like the Democratic side would do, right? So they're trying so hard to look neutral that sometimes they make the wrong call. And I just encourage them to really look at the law and the Constitution.
George Conway, so let's, from former President Trump's point of view, what is worrying about this? To Andrew Weissmann's point, his lead argument is more of a campaign, campaign slogan that he's used for anything that comes his way that he doesn't like. And it's not actually countering the eligibility question. the issue of engaging in insurrection, which doesn't mean a crime has to be committed and a conviction has to happen, just whether or not he engaged in insurrection and whether or not he is eligible.
Yeah, I mean, this is a bizarre document, and I think it reflects the weakness of Trump's position, actually. And let me explain why. If you took a seminar on appellate advocacy, the first thing they tell you is you have to focus an appellate court at any level on the 2 or 3, and sometimes 4 will be pushing it, key issues, the ones that you think are the weak spots in the decision that you're challenging. And that's on steroids when you go up to the Supreme Court of the United States and file a petition for a writ of certiorari. Because there, the Supreme Court doesn't take whole cases. It's not like 1803 Marbury versus Madison, where Chief Justice Marshall can look at everything in the case. They only look at discrete issues, and they choose those issues on the basis of their importance. And here, what Trump did on page 1, on the front inside cover, you're required to put the question presented. And the question presented here is this blunderbuss. Did the Supreme Court of Colorado err in ordering President Trump excluded from the 2024 presidential primary ballot? He's basically just throwing stuff up at the wall or throwing stuff up in the zoo cage and seeing what would stick. And so what this reflects, I think, is 3 things, the third of which is the most important. The first is, I don't know that he has real appellate advocates here of the sort that if I were a former president and a billionaire, I would want to have. I mean, Mark Meadows the other day hired one of the best advocates ever to appear before the Supreme Court, Paul Clement, who was a former Solicitor General in the Bush administration. Trump can't do that because people can't work. People don't want to work for him. The second is, I think this question reflects, the channeling Trump's narcissism. Oh, poor me, I was screwed by many which ways. And then the third reason, though, I think, is the fundamental weakness of his position. The 5th point in this brief, point 5, Roman numeral 5, is he didn't engage in insurrection. It's not number 1. And the reason is, it's because his arguments are very, very weak. If you look at the question in terms of should President Trump be removed from the ballot, it's kind of a shocking notion to those of us who hadn't lived until now in an era where public officials engage in insurrection. But it was familiar to the people who enacted the 14th Amendment. And when you go through the issues one by one, and the way lawyers are supposed to, his case looks terrible.